Imagine that the United States entered into a treaty that created a reservation for an Indian tribe. Fishing and hunting were culturally significant for the tribe and provided subsistence for tribe members. The treaty didn't specifically mention the tribe's hunting or fishing rights on the land. Instead, the government granted the tribe a reservation as, quote, a home, to be held as Indian lands are held, unquote. Did this treaty give the tribe the right to hunt and fish? Yes. A treaty doesn't need to explicitly mention hunting and fishing rights to reserve these rights for tribes. In this case, the phrase, to be held as Indian lands are held, created an implied right for the tribe because of the tribe's history of hunting and fishing. Tribes generally have authority to regulate Indians who hunt and fish on reservations. But what about non-Indians who hunt on reservations? Imagine that a tribe allowed non-Indians to hunt on its reservation. The tribe owned all of its reservation land. The tribe oversaw all aspects of hunting on the reservation, and the state didn't provide any government functions related to hunting. Can the state impose hunting regulations on non-Indian hunters on the reservation? No, because tribes retain exclusive authority to regulate hunting and fishing by non-Indians on Indian-owned reservation land. Now imagine that an act opened part of the reservation for non-Indian settlement. Even though non-Indians owned some of the reservation land in fee simple, the act didn't terminate the boundaries of the reservation. Can the state impose hunting regulations on non-Indian hunters on the non-Indian-owned areas of the reservation? No. In this case, the reservation boundaries weren't terminated by the act. This means the state doesn't have authority to regulate non-Indian hunting on the reservation, even if some areas of the reservation are owned by non-Indians. Finally, imagine that instead of opening the reservation to non-Indian settlement, Congress passed an act that allowed the federal government to purchase a large portion of the reservation. There was an implied intent to abrogate the tribe's treaty rights to exclude non-Indians from the reservation, and abrogate the tribe's right to regulate non-Indian use of the land. The federal government opened this land to the public and constructed a dam on the land. Would the state or the tribe have regulatory jurisdiction over non-Indian hunting on this land? In this case, the state would have jurisdiction over the non-Indian hunting because the tribe's right to regulate non-Indian use of the land ended when the government passed the act and opened the land to the public.